Madam Hearing Officer, I am ready whenever you are.
Okay, Mr. Price, are you ready? Okay. Are you ready? Yes. Okay.
May I ask who you are?
My name is Ashley Lamore. I am the hearing officer.
Your name is?
Ashley Lamore, L-A-R-M-O-U-R.
Attorney, aren't you?
That's correct.
Yeah,
Yeah.
I think I know you.
Yeah. I would let everyone know that Mr. Price, I think, had an attorney by the name of Miss Rhonda Stenger, who used to be my office mate. However, she and I were not partners, and we never shared files. So I have no knowledge of anything regarding what your cases were about. But you had an attorney who was a former office mate of mine. Okay. If we are ready to proceed, anyone who would be testifying, including Mr. Price, I'll go ahead and put you under oath as well. But Mr. Hartley, who will be your witnesses?
Dusty Carter and Mr. Price.
Okay. I will go ahead and put both of you under oath. If you could both raise your right hands. Do you solemnly swear and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Okay. Thank you. You may proceed, Mr. Hartley.
I call Dusty Carter to the stand. I think we're gonna set the cameras. We are recording this. We got the cameras on, and I'm gonna have the witnesses sit right here. Could you state your name and occupation for the record?
My name is William Carter. I'm the Code Enforcement Officer for Georgetown, Scott County.
Thank you. Mr. Carter, on or about April 3rd, 2017, did you receive a complaint regarding 167 Rucker Avenue?
Yes, sir, I did.
I'd ask the hearing officer to please mark the following document as Exhibit A.
Thank you.
We have copies for hearing officer, for the witness, and for Mr. Price.
Any objection? Any objection, Mr. Price?
Sorry,
Any objection to this exhibit being entered?
can I have time to read it?
That's fine.
Thank you. Okay, I read it.
Okay. Any objection?
Yes,
And what would that be?
I'll cite for you KRS.
Sir, that the objections would be something like foundational, lack of a foundation. It would not necessarily be statutory. It would be something as if, is this a business record or something, or basically a foundational reason to why this exhibit should not be entered, not necessarily a defense to the actual allegations. You'll have time to present your evidence as to why that this exhibit would not be true, but entering the exhibit would be whether or not there's a foundational basis for it, and that would be provided by Mr. Carter testifying. Does that make sense? And I should note, you do have right to be represented by an attorney, but you would have to hire and pay for that attorney.
Well, are you asking me if I object? I mean, do I admit the truth of this, or?
No, that is not what's going on. You're not admitting that that this document is true or false. Just whether or not there's grounds to allow it to be entered, such as, Mr. Carter, did you receive this record in the course of regular business keeping?
Yes, ma'am.
Okay. Those type of things, not whether or not these facts are true or false. Not whether or not these allegations are true or false, or this record document is true or false. That is not what that is not what he is, that's not what it's being entered into. Exhibit, he will testify, and that will be a determination that I make.
Well, look, I mean, my objection, I mean, if I have, this is my opportunity to object. Without citing the law, my objection is that I comply with Chapter 224 of KRS, which intends to keep recyclable materials away from the landfill, out of the landfill, and available for reuse. And all these materials cited here are subject to reuse, and that's what I do with them.
And sir, that is things that you'll be able to testify to. I'm not making a determination at this moment of whether or not that's true or false. It's whether or not there is a foundation that this document can be entered. And you'll be able to testify and have an opportunity to present your side.
Well, may I look at it one more time?
Sure.
Well, excuse me. I object to all of it because the man who complained is not doing anything about the landfill problem.
Okay. Well, sir, I'll note your objection and I will overrule that. And this can be entered in as an exhibit, but you will have an opportunity to present your own side and your own defense. You may proceed.
Do you recognize this document?
Yes, sir, this is a copy of a very plain general complaint that we received in the office, anonymous concerned citizen.
Could you please read the document?
It begins as complaint, 167 Rucker Avenue is a mess. The man who lives there is hoarding materials from construction sites around town and digging through people's trash. He hauls it back in a big wagon and stores it outside. There are piles of lumber and building materials stacked against trees and in the yard, creating a perfect place for rodents and snakes to live. The front porch is full of stuff that shouldn't be kept outside. I see him bringing back cans and bottles of junk. You can't see to the back of the property for all the overgrown brush. The roof has holes in it and is repaired with rusty sheets of metal held down with bricks. I hear he has no running water, no sewer, no electricity. Period. Concerned citizen. And we mark this received. It was signed in by the Administrative Assistant, Jordan Thompson, on April the 3rd, 2017.
So after receiving this complaint, did you visit the property at 167 Rucker Avenue?
Yes, sir.
I'd ask the hearing officer to please mark the following as Exhibit B.
Thank you. Any objection to it being entered?
That's a true copy of a notice of violation he left for me,
Okay,
so I guess there's no ground for objection.
thank you. You may proceed, Mr. Hartley.
Do you recognize this document?
Yes, sir.
Is that your signature at the bottom?
Yes, sir.
This letter refers to a Stephen D. Price as the owner of the property in question. Is that correct?
Yes, sir.
And this says the inspection date is April 7th, 2017. Is that the date you visited the property?
Yes, sir.
Could you read the first paragraph directly under where it states, "Dear Mr. Price"?
Dear Mr. Price, this is a notice of violation regarding an inspection that was made of the above referenced property pursuant to Chapter 9-2, Paragraph 2, 9-2, Paragraph 7 of the Georgetown Code of Ordinances and Section 302.5 and 304.7 of the International Property Maintenance Codes for the City of Georgetown and Scott County. Violations were observed which need to be corrected. Photos were attached.
I'd ask the hearing officer to please mark the following as Exhibit C.
Any objection, Mr. Price?
Can you give me a minute to look
Sure.
at this, please?
That would be fine.
May I ask why these blue tabs are
Yeah,
attached?
I will reference those in a moment. I will ask the witness to turn to those tabs.
Is this, which page does this tab refer to? Page 35 or page 36?
36.
36?
Yeah.
Dangerous buildings adjoining streets?
That's correct.
I object.
Okay, what is your objection?
My building has not moved in the probably 100 years that it's been there. And it's never been, the fact that it is closer to the street than any other building maybe in town. It's built right on the street. As a dwelling goes, it is exceptionally close to the street. But it is in no way a danger.
And that will be determination for the hearing officer, myself, to make. The objections are something like whether or not it's hearsay, foundational, things like that. Is this, Mr. Hartley, is this a ordinance that has been ratified and accepted by the city? Is this?
Yes.
Okay.
Yes, I was gonna ask the witness if
Okay.
if he could verify
Yes,
the foundation. But
So the objection is not whether or not your building is or is not. That is a matter of fact for me to make a determination. It is whether or not this is a true and accurate copy of the law that we will be reviewing. So your objection is overruled, and you could proceed, Mr. Carter.
do you recognize this document?
Yes, sir.
Could you turn to the last page of that document?
Yes, sir.
You see the signatures there?
Yes, sir.
Do you have any reason to believe this is not a true and accurate copy of Ordinance 16-009?
No, sir.
Could you please read Section 47 on that page?
Section 47 states, "This ordinance shall become effective October 1, 2016, and after passage and publication."
Could you please turn to the second tabbed page, that's page 36, and to Section 23,
Yes, sir.
and read the title of that section in bold, if you will, please?
Section 23 is Section 9-2 of the Georgetown Code of Ordinances is amended as follows.
Is this the same Section 9-2 to which you refer in the first charge of your NOV? Your notice of violation, excuse me, that's...
Yes, sir.
Okay. Could you read the first sentence of the underlined language beginning at the bottom of page 36?
For purposes of this section, failure to maintain lawfully required water, sewer, or a source of heat to a dwelling shall be conclusive evidence that a dwelling is unfit for human habitation. In a dwelling being used for residential rental, failure to maintain lawfully required water, sewer, electric, or a source of heat to a dwelling shall be conclusive evidence that a dwelling is unfit for human habitation.
Did you determine that the property was in violation of this section?
Yes, sir.
And by what evidence did you come to that conclusion?
Mr. Price's statement.
Have you subsequently determined that the property owner has remedied this violation?
Yes, sir. He provided a document to us stating that he had obtained water and sewer.
Thank you. Could you turn back to the ordinance, the same page, that being page 37, subsection 7. Is this the same section 9-2, subsection 7, to which you refer in the second charge of the notice of violation?
Yes, sir, it is.
Could you please read all of the underlined language?
Section 7, Open storage of equipment, furnishings, appliances, scrap, or salvage materials. There is caused or suffered any open storage of equipment, furnishings, appliances, scrap, or salvage materials, including metal, lumber, masonry, and other building materials not actively being used for construction, that is dangerous to public health, safety, or welfare, or that creates an unsightly condition that would reduce property value or promote urban blight. This section shall not apply where permitted by KRS 65.8840 or other applicable state or federal laws, or where such equipment, furnishings, appliances, scrap, or salvage materials are stored in a fully enclosed structure in a manner that prevents said items from being either a fire hazard or a harborage of pests and rodents.
I'd ask the hearing officer to please mark the following as Exhibit D.
Thank you.
I would also ask the hearing officer to take notice that I printed this from the official website of the Kentucky General Assembly on Sunday, May 21st.
Thank you, Mr. Hartley. Any objection, Mr. Price?
Sorry, I have to look at it before I can respond.
Okay. Once again, to please remember that we're not making a determination on what is written necessarily, as long as it doesn't violate hearsay, things like that. Proper foundational steps will have to be put into effect. We're not arguing whether or not this is true or false.
I object.
Okay, and what is your objection?
My objection is that the people, the legislators who drafted this statute are not sharing the burden of recycling and obviating or doing away with landfill. And you know, anybody who lives in Scott County knows that we have a mounting landfill problem that needs to be remedied by rerouting of the materials that are creating the landfill problem.
I respect your objection, Your Honor, and I respect your concern and your objection, but that's not a proper objection. I will overrule that objection, but you certainly have a right to present your side and opinion when it comes to presenting your side of this case. But I will overrule that objection and allow Mr. Hartley to proceed.
Thank you. The language you read referenced this statute. Are you aware of any provision in this statute that would make Section 9-2, Subsection 7 not applicable to Mr. Price's property?
No, sir, I don't believe so.
Sorry, Attorney Hartley, could you please repeat that question?
I asked him if there was any language in this statute that would make Section 9-2, Subsection 7 not applicable to your property.
Thank you.
I would ask the hearing officer to please mark the following as Exhibit E.
Thank you. objection, Mr. Price?
I have a question. Did you have a warrant when you made these photographs?
Those will be questions you can ask on cross-exam, but do you have an objection to these photos being entered into evidence?
Yes, I do, because there was no warrant served on me, and the U.S. Constitution and maybe the Kentucky Constitution both say that the government cannot, enter or inspect property without a warrant.
We will reserve that objection and get into the foundational issues and allow Mr. Hartley to proceed, but I understand your objection, and we will reserve that for further determination. Mr. Hartley?
Thank you. Do you recognize these photos?
Yes, sir.
Did you take these photos?
Yes, sir.
Did you take them on April 7th when you visited the property?
Yes, sir.
To your knowledge, is there any requirement for a warrant when you are taking photographs from a public street or from private property upon which you have permission to be?
No, sir.
Thank you.
Excuse me, Attorney Harland, he didn't have permission.
I'm sorry, I asked my question and he answered it. I didn't ask if he had permission to be on your property. I asked if he had permission to be on someone else's private property, if he needed a warrant to take pictures of an adjoining property.
And Mr. Price, you will have an opportunity to cross-examine him.
I have these same photos up on the screen. I'm going to flip through them one by one and ask you to tell me what you see from your perspective as a code enforcement officer.
In this first photo, there's an accumulation of building materials to the right, just on the inside of the sidewalk. There's an accumulation of items on the front porch.
You tell me when you're ready for me to go to the next slide, and I'll move on.
That's about the metal that's up on the roof, but I understand why that's there, so. Second photograph shows a clearer shot of the front porch.
To be clear, these are photographs of 167 Rucker Avenue, is
Yes,
that
sir.
correct?
Mr. Price's water collection buckets below the drip line.
Moving on. You tell me what you see here.
This is the pile of lumber, used building materials, and whatever's underneath that blue tarp. I
Bicycle,
don't know that there's anything wrong with what's under the blue tarp. I don't know what's under there.
bicycle.
We'll allow you to testify, Mr. Price.
This next photo shows also large stack of building materials, lumber, several windows. Everything being stored outside in the open. So.
Okay.
The next photo is the rear area, which are just additional piles of metal products, building materials that are stacked up against a tree, several locations.
I'm just going to move on through the rest quickly.
This one shows an accumulation of plastic bottles of some type.
Those white things that you see there in the background are some kind of plastic
Yes, sir.
container or
Jugs.
jug.
I don't know if it's the point, but the construction, I'm gonna use those to build a greenhouse. That's why they're there.
This photo with the blue tarp in the center is basically for all the building materials and lumber that's stacked up and piled against a tree there on the left.
Those are more bicycles under that tarp.
And then this is also another photo of the lumber stack.
All right, thank you. Based on the facts as represented by these pictures, did you determine there was a violation of Section 9-2, Subsection 7 on the property at 167 Rucker Avenue?
Yes, sir, I did.
Do you have any reason to believe this violation no longer exists at the property?
No, sir, I don't.
Could you please turn now to the first tabbed page of that ordinance, page 26?
Yes.
May I object, or I have Code Officer Carter, you told me yourself that you drove by there and saw that I had moved the lumber from in front of the house.
Those will be things that we can get into when you have an opportunity to present your side, but also when you have an opportunity to testify, because I think Mr. Hartley had said he was planning on calling you. But you will have an opportunity to address what you have done. I did want to confirm, Officer Carter, it was your testimony before I entered this Exhibit E into an exhibit that you had taken all these from the street or from someone else's property from which you had permission. Is that correct?
Yes, ma'am.
Thank you. They will be entered into exhibit as he was not on your property. He was on the street.
It had to be on my property.
I think if you, that would be my ruling, but I think if you look at a lot of them, you can actually see the sidewalk on some of them, but that would be my ruling based on his testimony.
Well, I'm gonna. So did he have permission to be on the other people's property?
I think he's answered that question already, Mr. Price.
Did you ask permission to be on other people's property? To take photographs?
I was given permission.
You were given permission?
Mm-hmm.
Thank you, Mr. Price. They've been entered into exhibit.
Okay, could you please turn to the section labeled 14 and read the highlighted language of that section?
The City of Georgetown, Kentucky hereby repeals the current 2003 edition of the International Property Maintenance Code and adopts the 2012 edition of the International Property Maintenance Code. This code shall regulate the conditions and maintenance of all property, buildings, and structures.
I'd like to ask the hearing officer to please mark the following as Exhibit F. And I would ask the hearing officer to take notice that I downloaded this document from law.resource.org, a public information database.
Do you have an objection, Mr. Price?
Yes, ma'am, I definitely object.
Okay, what is that?
This is nothing but a commercial publication drafted by a bunch of bureaucrats in Falls Church, Virginia, back in the 1960s, I think, who have no concept of doing anything to improve their lives with their hands, with their own labor. These are people who want to sit in an office in the vicinity of Washington, D.C., and imperialize this community here, just like Washington, D.C. imperializes or attempts to imperialize the rest of the world. By telling me and everyone else in Georgetown how they want us to live, people in Washington, D.C. How they are on a cash flow.
Mr. Price, I understand your concerns, but that is not a proper objection. Do you object via hearsay, lack of foundation, something along those lines, not necessarily the actual
Well, again, I know enough about it. Is this an updated version?
This is just selected excerpts from the 2012 International Property Maintenance Code.
Yeah.
Mr. Hartley, this has been ratified into the Georgetown ordinance.
By the provisions that Mr. Carter just read.
Okay. Mr. Price, I understand your objection, but I will overrule it and enter it as exhibit.
I object, Lamore, is that your name?
Ms. Lamore, that's correct.
this is full of language that has absolutely nothing to do with my property. Structural members, foundation walls, exterior walls, stairways, decks. There's no stairway in the house. Handrails and guards. There's no handrail, no guard, no skylight.
Mr. Price, I understand your concern regarding that. Mr. Hartley will be able to proceed, and I doubt that everything in here was actually intended to address your property, but we will see from Mr. Hartley continuing. But I doubt that he is meaning that every provision applies to you.
Well, I mean, that burdens the proceedings with unnecessary detail.
Okay, well, we can certainly.
Decorative features, there are no decorative
We
features.
can, Mr. Price, please allow me to continue. Mr. Price, we can certainly strike various pages that do not apply to you, if that is your concern. But
I will stipulate that I will reference the only two sections that are of concern.
I would be happy to mark out any other sections that do not apply to you. What two sections will be?
Sections 302.5, section 304.7.
Okay, I will stipulate that the hearing,
302.5 and what was the other one?
304.7.
304.7?
Yes, these are the same sections that were cited in the NOV, which you have already okayed.
Well, then, I have to object, there's no such, you must have misspelled. 304.7 should read roofs, not roots.
I think that would probably be something basically from that IPMC. I do understand the concern. I think that that is a minor issue, and then it does say the roof. But I will overrule that, but I will mark out and not acknowledge any section beyond the two that were cited on your violation. The hearing officer will only review those two sections. You may proceed, Mr. Hartley, and this has been entered.
Could you please turn to section 302.5?
Yes, sir.
Is this the same section 302.5 to which you referred in the notice of violation?
Yes, sir.
Could you please read that section?
302.5, rodent harborage. All structures and exterior property shall be kept free from rodent harborage and infestation. Where rodents are found, they shall be promptly exterminated by approved processes which will not be injurious to human health. After pest elimination, proper precautions shall be taken to eliminate rodent harborage and prevent reinfestation.
On your visit to 167 Rucker Avenue on April 7th, did you witness any rodents on the property?
On that day? No, sir.
Have you visited the property prior to April 7th?
Yes, sir.
On any of those visits, have you witnessed any rodents on the property?
Yes, sir.
In your regular course of work, do you see properties with rodents?
Yes, sir.
In your opinion, what conditions contribute to the presence of rodents on a property?
Outside storage of materials or anything that could make a house outside enclosure.
Nesting site.
Yes, sir, Mr. Price, a nesting site. Overgrowth. I really.
Thank you.
You will have an opportunity to cross-examine, Mr. Price.
Well, I just object that rodents is a very broad classification of mammals, from mice to, what, badgers, maybe? I don't know.
I'm not sure.
In your opinion, does the property at 167 Rucker Avenue exhibit some of the same characteristics you just described?
Yes, sir.
Thank you. In your opinion, is the property at 167 Rucker Avenue in violation of Section 302.5 of the International Property Maintenance Code?
Yes, sir.
Thank you. Now, could you please turn to Section 304.7 of the said Property Maintenance Code?
Yes, sir.
Is this the same section 304.7 to which you refer in the notice of violation?
Yes, sir.
Could you please read that section?
With the exception of the misspelling of roofs. 304.7, it says roots, but I believe it means roofs and drainage. The roof and flashing shall be sound, tight, and not have defect that emit rain. Roof drainage shall be adequate to prevent dampness or deterioration in the walls or interior portion of the structure. Roof drains, gutters, and downspouts shall be maintained in good repair and free from obstructions. Roof water shall not be discharged in a manner that creates a public nuisance.
I'd ask the hearing officer to please mark the following as Exhibit G.
Thank you.
This is Exhibit Z, once again,
G.
as in?
G is in goat.
G is in goat.
Do you have any objection, Mr. Price?
I guess not.
It,
I
this
mean,
will,
it's just gonna, any objection I have, you just overrule it anyway. Maybe this is not the time to say it, but briefly I'll say, the roof wasn't leaking. That's the function of a roof, is to keep the house dry, and it was working.
thank you, Mr. Price. No objection. I will enter Exhibit G into evidence.
Do you recognize these photos?
Yes, sir.
Did you take these photos on April 7th at 167 Rucker Avenue?
Yes, sir.
I have these photos up on the screen. I ask you to take a moment to familiarize yourself. In your opinion, do these photos show a violation of Property Maintenance Code, Section 304.7?
Yes, sir.
Can you explain how?
There is no gutter system, downspout system.
And so they don't have to comply with anything. But in the back, I have a drain,
Mr.
an
Price,
east,
you will be able to cross-examine him.
excuse me.
Please continue.
Mr. Price has assured me that he has maintained the underneath of these metal sheeting panels and that there are no leaks to the inside of the structure.
And if there were, I would be up there repairing it.
Mr. Price, you will have an opportunity to defend yourself as well as cross-examine.
So, where the Property Maintenance Code, Section 304.7 states, roof drains, gutters, and downspouts shall be maintained in good repair and free from obstructions. Is it your opinion that the property is in violation of that provision?
Yes, sir.
Thank you. Do you have any reason to believe this violation no longer exists at the property?
This specific violation
Yes, sir.
still exists.
I'd ask the hearing officer to please mark the following as Exhibit H.
When you say that the specific problem still exists, you're referring to the roof?
You'll have the opportunity to cross-examine the witness.
Is there any objection to Exhibit H being entered, Mr. Price?
I'm sorry?
Is there any objection to Exhibit H being entered?
I guess it's just, well, I will, he did not, if he put this on my wall, he was on my property without a warrant.
I do understand that concern. I think that Code Enforcement B, number 3, actually allows that they can post a copy of the citation. I do not necessarily see a requirement for a warrant, but I do understand.
Read the U.S. Constitution, please. Amendment 6 of the Bill of Rights.
Okay.
Do you have a copy of it handy?
I do not, Mr. Price, but is there any exhibit to Exhibit H being entered? I understand your objection to lack of warrant. Would that be your objection?
Yes, ma'am.
Okay. I will reserve that and take that under consideration. Mr. Hartley, please continue.
Thank you. Do you recognize this photo?
Yes, sir.
Did you take this photo on April 7th at 167 Rucker Avenue?
Yes, sir.
Can you tell me what this photo shows?
This is a copy of the notice of violation that is taped to the exterior of Mr. Price's house.
And why did you tape that notice there?
Under the new code enforcement regulations, we are required to mail a copy to the registered property owner and post a copy on the property.
So did you also mail a notice to the property owner?
Yes, sir.
Thank you. Please turn your attention again to the notice of violation. Give you a chance to pull that back out.
Excuse me.
Yes.
I need to go to the restroom.
Okay.
I'm sorry.
That's fine. We can take a
break.
5-minute break.
I'm sorry.
We can take a 5-minute break. And
Thank you.
gonna bring over one of those W-9s in about an hour. I admit I did not notice the time. Has it been 5 minutes? Are we ready to proceed? Mr. Hartley, you can proceed.
Thank you. I think I asked you to please turn again to the notice of violation. Can you look where it says reinspection date? Can you please tell me what that date signifies?
This is the 5-day period passing authorized by this notice. It explains that we'll return after this 5-day passage for purposes of reinspection.
So, did you visit the property at 167 Rucker Avenue on April 13th, the reinspection date?
I believe we did, yes, sir.
I'd like to ask the hearing officer to please mark the following as Exhibit I.
Thank you. Any objection, Mr. Price?
Is this is just to be a true and accurate copy of the, this is a copy of the citation, right?
He will testify to foundation, but that's what it appears to be. Or a re-inspection, but
Well, if I mean, to really be on the, I really ought to compare it with the copy he left me, I mean, to make sure that,
okay,
well, I'll tell you what, well, if you don't mind, give me just a second.
okay.
It looks like the same. I guess if it isn't, I can discover it later. No objection.
Thank you. You may proceed.
Do you recognize this document?
Yes, sir.
Did you generate this document on April 13th, 2017?
Yes, sir.
Thank you. I'd like to ask the hearing officer to please mark the following as Exhibit J.
Thank you.
This citation was exhibit what?
I.
Aye.
Thank you.
Do you have any objection to entering Exhibit J.
It appears to be the citation that you posted on the wall, correct?
Yes, sir.
No objection?
Thank you.
No, I mean, my objection is constant, but to get on with things, I will not object.
Okay.
My objection is that you all are not doing the work. I'm doing the work, and you're trying to tell me how not to do the work. That's my overall objection.
Okay, that will be something for you to address in your direct, in your defense. But as to this specific exhibit, which I think is Exhibit J, you are telling me that you do not have an objection to this.
Correct, yes, ma'am.
Okay. Please continue, Mr. Carter.
Do you recognize this photo?
Yes, sir.
Did you take this photo on April 13th, 2017, 167 Rucker Avenue?
Yes, sir.
Can you tell me what this photo showed?
This is a copy of the citation delivered to Mr. Price's property, enclosed in a clear vinyl sleeve, taped to the exterior of his property.
Why did you post this on Mr. Price's property?
We are required to post a citation, same as we do with a notice of violation on the property, as well as mail one to the registered property owner.
Did you also mail this notice to the property owner?
Yes, sir.
I have no further questions of this witness.
Thank you. And I would make note that I have, all the exhibits are entered into, exhibits for the city, excepting, I reserved Exhibit H due to Mr. Price's, objection about the search warrant, which I'm going to consider, and I will make a decision on that when I do my written findings of fact. I understand Mr. Carter's testimony that he both mailed and posted the citation, but I will make a ruling regarding Exhibit H being entered in my written findings of fact. Mr. Price?
Exhibit what?
Exhibit H.
H is in Howard?
Yes. I will make a decision on that in my written findings of fact, but all the other exhibits were entered.
And Exhibit H is, well, then, the same, I have to, the same objection is for Exhibit H is, I enter the same objection for Exhibit J, I'm sorry.
Oh, I'm sorry, sir, that has already been entered. You did not make that objection at the time of entering. But I will make that note for Exhibit H and make that determination in the written findings of fact. But I will also note that Mr. Carter testified that he mailed a copy to you as well as posting it.
Yeah, but the objection is that he was on my property without a warrant.
I understand that, but that time has elapsed for you to object to Exhibit J. That time to make that objection was when it was being entered, and you did not do so. However, you do now have an opportunity to cross-examine Mr. Carter.
Well, what a lucky guy I am. This is my opportunity. This is why they call the United States a land of opportunity, I guess. Because somebody gets up and tries to do something about the problem at the landfill.
Mr. Price, do you have a question for the witness? Please ask questions to the witness. Do not berate or yell at him.
Yeah, I have a question for you, William Carter. Same question I asked you in your office a couple of weeks ago, maybe it was. I asked you, when you came on my property, did you observe any foul odor or unsightly consequence of my management of septic waste for fertilizer? I asked you that question. And do you recall your response?
No, sir.
Well, your response was no. Your answer was no. And I don't mean to berate William Carter. I guess who I would really berate is the people who presume to sit in positions of authority in rooms where they have no understanding of the reality of the outdoors. Where all this work has to happen if we're gonna do something about the landfill
Do
problem.
you have a question for Mr. Carter?
Yeah, another
Okay.
question. You don't recall me asking you, I'm gonna repeat the question. You don't recall me asking your office a couple of weeks ago, when I came in your office, and did I ask you to if you could locate the date and pinpoint the date of the complaint against me?
Yes, sir.
And at that point, do you remember how our conversation continued?
Somewhat, not exactly.
Well, do you remember, could you tell could you tell this assembly about that conversation?
You asked me if I had smelled anything, and I said, no, sir, I didn't.
Right, and did you see anything that would indicate management of sewage or septic waste?
No, sir, I didn't look for anything like that.
And you didn't see anything like that? Okay, well, I asked, do you remember the context, the reason I asked you the date for the complaint? Do you remember I told you, I confided to you a circumstance. Do you remember what I confided to you?
No, sir, I don't remember. Can you refresh my memory?
Yeah, well, I mentioned a commercial firm known as Roto-Rooter. Did you remember my mentioning?
Yes, sir, had been doing work at the end of the street, yes, sir.
Yeah, right.
Yes, sir.
And I don't know if this is the time to do it, but I called Roto-Rooter last week, and the lady there confirmed to me that Roto-Rooter worked on Rucker Avenue on my street from March 31st through April the 11th. And you received this complaint on April the 3rd, right?
Correct, April the 3rd.
Right. So, I don't know if this is a time to maybe, you asked me if I have questions for Mr. Carter.
That's
Okay,
correct. He is the
let me
witness.
confine my input to questions to William Carter.
Thank you.
You didn't observe any ill odor or any unsightliness that would indicate to you management of septic waste? I'm gonna repeat the question, and your answer is no, is that correct?
Correct.
All right, and did I not tell you that I had been on the roof? And there were, when you took these pictures, there was obviously a tree limb on the roof. And I told you, do you recall that I told you I had been on the roof?
Yes, sir.
For the hearing officer's understanding, what photo are you relying on?
This is Exhibit G.
Thank you.
Exhibit G clearly indicates a tree limb on the roof of the porch. And I told you that I had been on the roof, removed the tree limb, and I replaced a loose shingle. But do you remember what I further said?
That there were no leaks in the roof?
And what? Remember I said that, I think maybe I used it, but you responded, if it's broke, don't fix it. You remember saying that?
If it's not broke, don't fix it, yes, sir.
Right. And so I explained to you, or let me ask you, do you remember that my major concern about clambering about on the roof would be that it would do what? If I were up there doing any unnecessary work on the roof, it could cause the roof to do what?
I don't recall.
Well, why would you have responded, if it's broke, don't fix it?
But if it's not broke, don't fix it.
I mean,
If
yeah,
it's not leaking.
if it's not broke, don't fix it. Right. Why, you admit that that was your response, right?
Yes, sir.
Well, for the benefit of this group, my concern was that the more work the more movement I made, the more footprint I put on the roof, is that I would increase the possibility of start leaking, and it does not leak. You remember that conversation?
Your statement was it doesn't leak now.
Yeah.
Yes, sir.
So that's why, but I told you that I had, do you recall mention my report to you in regard to this shingle that was hanging down here? There is one shingle hanging right here, right in the center of the porch roof. You remember my explanation to you about that?
Yes, sir, that's what directs the water off those sheets of tin down into the buckets.
Well, that general area of the roof does that. That's right. I explained to you that I capture water
Yes, sir.
from the roof.
That's why you said that opening was there. So you
No, it's not. The opening is there is so that I can put a ladder to go onto the roof.
Yes, sir.
But that's the only part, and I don't put a bucket there, but the remaining overhang allows water to drain for capture.
Mr. Price, I understand you will have an opportunity to testify to all this. Try to limit it to questions for Ms. Carter. Mr. Carter, do you have any other questions for him?
Mr. Carter, you said, let me ask you a question. Have you driven, or have you been, have you viewed my property since filing of the appeal? I think I filed the appeal on, well, let's just say, have you viewed the property since the reinspection date?
Yes, sir.
Can I ask when?
Friday.
This past Friday?
This past Friday, yes, sir.
And did you notice any difference from the date that you took these photographs that are exhibit, first exhibit that you handed me?
Yes, sir.
Okay, and would you say that the changes you observed constitute compliance with your demand for a remedy?
To a degree, yes, sir. It's good progress.
Right, okay, thank you. Let me see if there's any other questions. And does, in the citation here, it says, if you remedy the violation with a time period specified, the penalty shall be waived. Did you tell me that as long as if I made progress, that you would allow, I forget the exact language, but let me put it this way. Did you use the words, you said, did you offer me, if I needed more time, did you offer me the option to call you and tell you that?
Yes, sir.
Right.
Until such time you request a hearing, an appeal, and then my clock stops. I don't go back on the property to do any further inspections, or you continue with anything. The penalty phase of the citation goes on hold during that appeal process. Everything basically stops as far as the enforcement end.
But you did go back this past Friday though, right?
Yes, sir, I did.
Right. Just,
Basically, your request, last time I spoke to you, you said I could come by anytime and have a look at what you've done.
yeah, and your opinion is that I have moved in the direction of compliance.
Yes, sir, you're making progress, yes, sir.
Yeah, right, okay. And did you, that's the language, you said if I were making progress, that you would allow me more time as long, or is that correct or not?
Yes, sir, that's exactly correct.
Okay,
Once you make an appeal, my actions are on hold. I can grant no extensions, I can do no other actions. Once someone makes an appeal, the enforcement end is on hold until that appeal is heard, which is today.
well, I will explain, I don't, my reason for requesting the appeal was because I wanted to raise the issues that big issues. that-
Mr. Price, please remember to ask questions of Mr.
Okay,
Carter.
all right, I'm
Do
sorry.
you have any other questions?
Does this, I'll just say, I hope that this body will admit and take note of what Code Officer Carter how his responses to my questions.
I have some questions, and I have obviously taken note of Mr. Carter's responses, but I do have a couple questions as well, Mr. Carter. It was your testimony, I think that 9-2, subsection 2, regarding the water and sewer,
Yes, ma'am?
was that taken care of? Is that problem still continuing?
To my knowledge, that has been taken care of. Mr. Price provided us with documentation that he had contacted.
Here's a work order right here.
Okay, we will get to that on your director, can admit that as evidence. Regarding 9-2, subsection 7, what was progress on that when you went by on Friday?
Mr. Price was in the process of constructing a storage facility
Okay,
behind his house.
and to what extent was progress made?
He had an area cleared off and was sawing on a piece of wood when I was there taking photos.
Would it be, in your opinion, substantial progress, or?
There was progress made. I'm not gonna say it was substantial progress on that structure, but as far as, yes, ma'am, progress was made.
Okay, regarding 302.5, what is the status of that in your regards from the Friday observation?
There were still stacks of building materials and lumber and things piled. And, these could be harbors for roads and stacks and things.
304.7, if I understood your testimony correctly, based on statements by Mr. Price, you had said that you did not believe or did not have an understanding that the roof leaked. Was that correct?
That is
Testimony?
correct.
Thank you.
He had specified that it did not leak.
Okay, thank you. Mr. Hartley, who is your next witness?
Mr. Price.
Okay. Would you like him to take Mr. Carter's place?
Please.
Okay. You may step down, Mr. Carter. Thank you.
Yes, ma'am.
You want me to
You will have an opportunity to present your own direct, but I think that you're being called as Mr. Hartley's witness, but you will have an opportunity to present your own defense.
okay, no, just.
You will answer, yeah, at this opportunity, you will just answer whatever questions Mr. Hartley asks you, and I would ask that you recall that we administered the oath at the initiation. Thank you. We are ready to proceed, Mr. Hartley.
Thank you. Could you please state your name and address for the record, please?
Stephen E. Price, I live at 167 Rucker Avenue, Georgetown.
I would ask that the hearing officer please mark the following as Exhibit K.
Thank you. Do you have any objection to these letters, Mr. Price?
No,
Do you recognize this document?
yes, sir,
Did you write this document?
yes, sir,
Did you deliver this document to my office on or about April 10th?
yes, sir.
Could you please read the postscript in the document?
Though you yield to state government and accommodating motor manufacturer, KRS 413.072, copy of which I tender herewith, indicates that Kentucky law accommodates agriculture, horticulture, and silviculture with exemptions from standard zoning, building, and nuisance codes, plural. Though Logan Askew and KLC lawyer Jacobs persuaded Judge Isaacs to rule that 5 acres are required under KRS 413.072, you can read for yourself that no such requirement appears in the statute. Isaac's ruling is subject to appeal. Your continued refusal to honor the exemption is under KRS 522.020, official misconduct. See copy herewith, a copy that is of KRS 522.020, I guess.
Thank you. Is it your contention that KRS 413.072 exempts your property at 167 Rucker Avenue from Georgetown zoning, building, and nuisance codes?
No, not under Judge rulings, not under Judge Isaac's ruling. Under the statute, yes, but under Judge Isaac's ruling, no.
I'd ask the hearing officer to please introduce, to please mark the following as Exhibit L.
Thank you. Is there any objection to this, Mr. Price?
Give me just 1 second, please.
Sure.
No.
You may proceed, Mr. Hartley.
Could you please read the case number at the top?
Me?
Yes, please.
Case number 11 CI 974.
And the bold underlined language at the top?
I don't have any underlined language.
Sorry, I'm referring to the word order. Does it
Oh,
state order at the top?
Order. Oh, I'm
Okay.
sorry. Order, yeah.
Could you please read all of the second paragraph?
Petitioner's motion for declaratory judgment is granted. This court finds that respondent's property, specifically that property located in Georgetown, Scott County, Kentucky, at 159 Rucker Avenue, Deed Book 185, page 384, 167 Rucker Avenue, Deed Book 277, page 126, Lexington Avenue, Deed Book 306, page 467, Deed of Correction, Deed Book 319, page 80, and Royal Spring Avenue, Deed Book 306, page 463, is not subject to the exemption set forth in KRS 100-203.4, KRS 198B.060, Item 3, and KRS 413.072, as the property does not consist of 5 or more contiguous acres, and thus is not entitled to an agricultural use exemption. Price is therefore subject to all applicable statutes, ordinances, codes, and regulations concerning the use and upkeep of said property, including but not limited to the zoning, Kentucky Uniform Building and Property Maintenance Codes as adopted by the City of Georgetown Code of Ordinances.
Thank you. Do you have any reason to believe this document is not what it purports to be?
No.
I'd ask the hearing officer to please mark the following as Exhibit M.
Thank you. Do you have any objection to this exhibit, Your Honor, Mr. Price?
What Attorney Hartley is attempting to show here is that the appeal was dismissed, and in fact, the appeal was dismissed, but what he fails to indicate is that my agreement to I signed, it's not here, you didn't present that, Attorney Hartley, but I signed a document authorizing my, or agreeing to abandon, I agreed to abandon the appeal, and that signature was extorted.
Okay, Mr. Price, that will be something you'll be able to testify to. But regarding this exhibit, I will take judicial notice of it, absent an objection to discount that. But,
No, it's true and accurate.
okay. Then this would be entered into as Exhibit M. Mr. Hartley, please continue.
Do you recognize this document?
I have to say, I'm not as acquainted with this one as the others, but, I imagine it's in my files.
Could you read the highlighted caption?
Appeal from Scott Circuit Court, action number 11 CI 00974.
Could you please read the paragraph that starts with "this court"?
This court has considered what is being treated as the party's joint motion to dismiss the appeal. Having considered the motion, the court orders the motion be, and it is hereby granted. The appeal is hereby dismissed this date.
Do you have any reason to believe this document is not what it purports to be?
No.
Do you still believe your property is exempt from the zoning, building code, and property maintenance code provisions of the Georgetown Code of Ordinances?
No, as I said earlier, under the statute, it is, but under Judge Isaac's ruling, and because my appeal of Judge Isaac's ruling was dismissed, then Judge Isaac's ruling is in effect.
Could you please read the date that this document was entered at the bottom left?
What date it was? Yeah, it was dated, entered November the 6th, 2014.
Thank you. I'd ask the hearing officer to please mark the following as Exhibit N.
Thank you.
Thank you.
Mr. Price, do you have any objection to Exhibit N?
No, this is exhibit, what is it?
N. Nancy.
N,
Nancy.
exhibit N.
Yes.
And the one before that was exhibit, please?
M.
M as in Mary?
That's correct. Mr. Hartley, please continue.
Thank you. Do you recognize this document?
Yes, sir.
Did you write this document?
Yes, sir.
Did you deliver this document to my office on or about April 13th, 2017?
Yes, sir.
Could you please read the highlighted language?
I write to ask you to authorize a 1-week postponement of my obligations to Code Officer Carter so that I can graft said cyan buds and so that I won't lose them to broken dormancy, and there's a footnote at the bottom, or to spoilage.
I'd ask the hearing officer to please mark the following as Exhibit O.
Thank you. Do you have any objection to Exhibit O, Mr. Price?
This is apparently a true copy of a letter that Attorney Hartley wrote me. Does that constitute, if I admit that, does that, is that what you want me to say, admit this is a true document, or a true copy, or?
Do you have an objection relating to foundational or hearsay or some such? Otherwise, foundationally, Mr. Hartley will be able to ask you questions to see if this is appropriate, but I'm not asking, I cannot give you legal advice, so we can reserve until the foundational issues have been taken care of through questions with Mr. Hartley, asking you questions. Mr. Hartley, if you could proceed.
Well, let me just respond if I may.
Okay.
This says here that a reinspection will be scheduled around April 28th. William Carter showed me that he had a copy of this letter, and he said that won't happen because of you filed an appeal. That's what he told me. He said no, there's no reinspection allowed because I filed the appeal. And you said, right, it sounded in this letter as though you encouraged me to file the appeal within 7 days. I mean, I won't attribute that to you, but it says right here, the extension for time does not, for compliance, does not extend the 7-day appeal period, which expires on April the 20th. So on or before April 20th, I filed the appeal.
Mr. Price, this is the time that you're the witness for Mr. Hartley, so he's going to ask you questions, but you cannot ask him questions necessarily. But you can certainly recall Mr. Carter when it's your turn to present your side.
Okay, you want me to answer your question?
Do you recognize this document?
Yes, sir.
Is the document dated?
April 17th.
Thank you. Could you please read the highlighted language?
Your request for extension of time for 1 week is granted with the following conditions and limitations. The extension of time for compliance does not extend the 7-day appeal period, which expires on April 20th, 2017. A reinspection will be scheduled on or around April 28th, 2017. If at that time the property is not in compliance, the city will proceed to abatement of the violations. Further requests for extension of time will not be granted absent proof of substantial progress toward remediation of the violations.
I have no further questions for this witness.
Okay. So it's my understanding that your testimony is that the reinspection did not occur, Mr. Price? Or not to your knowledge, you can,
I was under, I thought that I told Carter, in fact, there's a letter in the file, it should be in his file, I know it's in my file, it's in that pile of paper right
okay,
over
you'll be
there.
able to present that.
I'm sorry?
You'll be able to present that.
I wrote them and said, I'm operating as though you intend to inspect my property on Friday, April the 28th.
Okay.
Because I didn't know that filing the appeal would suspend any reinspection.
Okay. So it's your testimony that you're unaware of whether or not the reinspection took place on April 28th. Thank you.
I'm aware that on the basis of what Carter told me, he said there would be no reinspection
Okay.
because you filed the appeal.
Okay. Thank you, Mr. Price. I don't have any other questions. Do you have any other witnesses or exhibits, Mr. Hartley, or is your case closed?
Case is closed. I would like to make a final statement whenever that time is appropriate.
Okay. I think we will do so after the two sides present their defenses or their sides. Mr. Price, the city, having now closed their case, is now your time to present defense. Would you have witnesses to call?
I wasn't aware that I was going to be allowed to call any witnesses. Nobody ever told me that. I would probably have witnesses to call,
Okay.
but nobody advised me that I had that option.
I think that is actually in the ordinance, if I recall correctly. I think that is listed out in the ordinance.
What ordinances are you referring to?
I think it's 16-009. It's relating to the code enforcement and also the enforcement proceedings and how that they would run. Would you have a statement in your own defense?
I'm sorry?
Would you have a statement in your own defense?
Yeah, well, I want to, if you don't mind, can you tell me where this ordinance allows me to call a witness?
I know it talks about the code enforcement board shall have the power to subpoena alleged violators, witnesses, and evidence. So I take that to mean that both sides have the opportunity to call witnesses. And that would be, I think,
Where are you reading that?
that would be in 5C, the powers of the code enforcement board, and then
Item 5,
yes.
C,
Yes. It says, they shall have the power to subpoena witnesses, so I took that to mean, and that any could. And then on number 10, hearing notice and final order on, see, D, all testimony shall be taken under oath and recorded. The board or assigned hearing officer shall take testimony from the code enforcement officer, the alleged violator, and any witnesses to the violation offered by the code enforcement officer or alleged violator.
So, yeah, it obviously, it's me, the violator can provide a witness.
That's correct, under number 10. D, if I recall. Do you have any testimony that you would like to
I don't have
present?
any witnesses, because I
Okay.
was not aware of that. I wasn't aware that I could provide a witness.
I understand it's difficult to proceed pro se. Do you have any testimony you would like the hearing officer to consider?
Yeah, well, I've got some exhibits of my own maybe that, unfortunately, I didn't have time to make copies for everybody, but this is a work order dated, this is no work orders, this is a history of the water company's work on my place since 4/28.
Please show that to Mr. Hartley, and if he doesn't have an objection, then I can consider that. If there is a copy available, we can make copies. Otherwise, I can take that one copy if Mr. Hartley does not object, because he would need to be provided.
Well, I think I can, I've got a copy of the two documents here that indicate my compliance with your requirement that my property be connected with what it called in the ordinance legally required water and sewer.
I would make note that I think Mr. Carter had indicated that you were in compliance with that provision.
Yeah, okay,
As
well,
well.
I just wanted to, I mean, I've gone to some trouble to document that.
Sure.
and
I appreciate it.
I'll show you.
I have no objection.
I will mark these for Mr. Price's Exhibit A.
Yeah, I don't suppose there's any way we can make a copy of that, is there? 'Cause that's my original.
We can make copies after the hearing.
Okay, we can make copies for you.
Okay, all right.
We'll mark these as Price Exhibit A.
And further, I have here exhibits to show my reliance, my effort to comply with with William Carter's code officer's I operated on the basis of what he told me that I needed to get busy using up all those building materials. I mean, the building materials are there because I intend to use them. And he said, well, if you intend to use them, you better start building something and using them. And that's what I wanted to show you in these photographs.
I appreciate it. If you could please show those to Mr. Hartley, and then if,
Okay,
And we
just
will
a second here. sorry to hold you up.
That's okay.
Y'all have overwhelmed me with a lot of exhibits, and I've got to get them out of the way so that I can see my own exhibits. This is part, and I'll show a little bit more, but this is the shed that I told William Carter I intended to build. And this photo was taken yesterday. There's about half the floor joists laid. The remainder of the building comes down this way, and the remainder of the floor joists would be laid where you see bare ground there. But I'm delaying that because I want to excavate the storage area underneath the floor. So that's why those, those floor joists are not attached. They're laid there, but they're not, I don't want to use nails. I'm going to use wooden pins so I don't make any noise. But anyway, they're not attached, and I'm going to take them back and dig a basement, or what you would call, it's not really a basement, but a storage area underneath the building. And so that's, and this here you can see it from the side. This is in the photograph that Attorney Hartley showed the court a while ago. I showed this group those jugs. There were a lot of jugs hanging here on the back side of the house, and those jugs have been removed, relocated, and this is another side view of the floor joist. Here's a picture of the areas. These are pictures of the areas in the photographs that where a lot of where he located a lot. Where there was a lot of wood stored, lumber stored near the front of the house, which has been moved back to the construction site, back to the building site. And if you compare that photograph, this photograph with the one he took, there was a big pile of lumber right here, right near the street on the day he took the first photograph, which I think was maybe April the 7th. This is my front porch. You can see that the only thing that remains there on the right half is these ladders. There's a stack of hay there for my neighbor, for her dog, to bed her dog on. I cut the hay and I'm offering it to her to bed her dog. And all the fabric and other items that were on the desk are gone.
Mr. Price, since I'm not being able to see them, just show them to Mr. Hartley and see if he has the objection, and then we can go into them when I have them in front of me too.
I don't have any objection to the entry of any of these.
Well, there's two more. These are shot. These are photographs of the boring machine I'm going to use to mount the studs into the plate, so I don't have to use any nails. Big problem. Reason I'm here today is because I have tried to limit noise in my neighborhood. Under KRS 22430-100 of KRS, noise is a, how's it say? I'll read it to you in a minute. But anyway, this is a boring machine that can be, you bore the holes in the sill or the plate and cut a peg on the studs and put the peg in the hole so you don't have to use nails. Doesn't make any noise.
And these will be entered into Exhibit B for Mr. Price. Mr. Price, regarding all these photos, were you the person who took these photos, or were you present as you're in some of them? Were you present for each of these photos?
Some of them I took, some of them I was in
Okay.
subject. I took the,
That's
all
fine
these.
as long as you were present. And let me ask, what date approximately were all these taken?
And, this was taken yesterday,
Okay, what is that date?
21st,
Okay.
5/21.
Okay.
This was taken yesterday. No, that was taken today, 5/22. Those were taken 5/22 today.
Both of these, okay. Okay,
These 5/22.
okay, all of these?
ma'am.
Okay, and how about these?
Those, Saturday.
520.
Yep. Yeah, that's right.
Okay,
Yeah.
so, are these, let me ask a few more foundational questions. You were either present or took these photos. Are these a true and accurate representation of the scene on the dates that you took these photos?
Yes, ma'am.
Okay.
If you hang on just a minute, there are more photographs. I need to find, if you give me a minute, I'll find them here.
No objection, as what I understand, I will enter these in as Exhibit B for Mr. Price.
Here they are. This photograph was taken in the middle of last week, and I had to change my design because I read, and I'll get to it, I'll point it out in a minute. I read in a book, I'm not a professional builder, I had to read, you know, to go along, with the work I'm doing.
Mr. Price, just go through and kind of shuffle through, hand them to Mr. Hartley and see, he can kind of quick.
This is the initial construction site had to be dismounted due to an error I made regarding placement of floor joists. And so then I had to start anew, on Friday I started again, so here's the section again. Same site, new structure, new design, and I'll explain why I had to redesign it and start over. These, those were taken in the middle of last week. These were taken Saturday, and this was taken Saturday. No, yeah, this was taken Saturday. And this shows the same lumber pile that Carter photographed. I've laid the lumber out, sorting through it so that I can apply it here to the job.
I have no objection.
Okay, thank you. Mr. Price, I
You want
think,
the dates on this?
yes, please. What were the dates these were taken, please?
This was Saturday, it would have been the 20th, 20. These were the middle of last week, say about the 17.
Okay. Just gonna look at dates, but say 5/17, and then these,
These were Saturday.
okay. And were you present for all these photos? Are these a true and accurate representation of the scenes on the dates the photos were taken?
Yes, ma'am.
Okay. They will be entered as, I think, an additional Exhibit B for Mr. Price.
And could you all make copies of those and give it back to me after the hearing?
That is what I understand is going to be happening.
All right, okay. Well, let's see here. The citation that Carter gave me explicitly says that if I would, what did I do with it? Do you have a copy of the citation there?
I do. I'm looking at it right now. I think
Can you read that, there's a,
at the bottom.
well, hang on, just let me find it. Here it is right here. I wanted, this is my time to
That's correct. I don't think that is the same. I'm looking at the initial violation. What exhibit are you looking at?
this is a citation.
Yes, it was a specific exhibit. I don't know if Mr. Hartley recalls.
Yeah, I can tell you just a moment. That would be Exhibit I.
Thank you.
That's right, exhibit I. Okay, I'm gonna try to defend this is my opportunity to defend myself
That's
against this notice of violations
That's correct.
and the citation, right?
That's correct.
My suspicion is that a man who works for Roto-Rooter Corporation is the party who complained per exhibit, whatever it was, the first exhibit,
A.
right, okay. And I want to tell you, I want to read to you KRS 22430-100.
I'm sorry, what KRS was that?
22430,
Two.
2430-100. This is findings and policy of the Kentucky Legislature. The legislature finds and declares that excessive noise is a serious hazard to the public health and welfare and the quality of life. A substantial body of science and technology exists by which excessive noise may be substantially abated. Each person has a right to an environment free from noise that jeopardizes his health or welfare or degrades the quality of life or lowers property value. It is the policy of the state to promote an environment for all people free from noise that jeopardizes their health or welfare or degrades the quality of life. And this is the second time that I have been cited by the Code Enforcement Office of Georgetown for failure to provide what's called legally required water and sewer. And this time, just like the first time was in 2008. My neighbor, next door neighbor at that time, 2008, had hired a backhoe to replace his sewer line. And he'd only bought the house in 2003, and the man who had the house before him did not actually live in the house, and he had installed a new sewer. And I knew that because I had lived there. So I walked down, this backhoe was shaking the whole neighborhood, with noise and vibration, to dig a big ditch to lay a new sewer line. So I walked down the street, my neighbor was standing there. I said, "What are you doing?" He said, "I'm replacing the sewer line." And I told him, that's a new sewer line. It's not very, the man who lived there, never even used it. But the point is, don't you have a rototiller sitting back there, and didn't you tell me you were gonna raise a garden? He said, "Yes." I said, "Listen, I'm gonna give you some advice. You don't need a sewer line at all. If you're gonna raise a garden, you should be collecting septic waste, processing septic waste to make fertilizer, because you're gonna have to have fertilizer if you're gonna raise crops." And he looked at me and did not answer. And a week later, I got the code officer came to my house, handed me a piece of paper, and told me to go to the health department, because he had a complaint that I was not using the required sewer line. So my neighbor, I was trying to help my neighbor and the neighborhood by eliminating this noise hazard, unnecessary noise hazard of the backhoe replacing the sewer line. I was trying to advocate for KRS 22430-100 to reduce noise, unnecessary noise in the neighborhood. And in 2008, in response to the code officer, at that time his name was Jesse Jones, I went to the health board and we convened twice during the summer of 2008, and I explained to the health board my processing of septic waste for fertilizer and my requirements for fertilizer as a horticulturist. They told me you can't do that. You can't bury it anymore. So I ceased and said, you got to hook up to the sewer. I did that. I hooked up to the sewer, and at that point, I did a lot more research on other ways to process septic waste other than burying it. And I wrote a letter to the health department, health board, in it was in September 2009, explaining that on the basis of my research, I was going to improve the processing and not simply bury it, but to process the septic waste above ground by inoculating it with leaf mold and mixing it with leaf mold and making it a more valuable product. And if they had any objections, to let me know. And I told them that if I do that, I will disconnect from the sewer. Please let me know if you have any objections. They didn't write back. I waited several months and they never wrote back. So I disconnected the sewer and carried on with an improved processing of septic waste to make fertilizer. And that's what I've been doing since 2009. And it works so well. There's no odor. There is no, as William Carter will tell you, as I already said, there was no odor and no unsightliness on my property that he could attribute to my processing of septic waste. So processing of septic waste could revolutionize the way people live, while at the same time eliminating shipments of sewage sludge to our problematic, infamous, increasingly ill-famed landfill. And if you, I think Hartley, Tony Harland, I saw you at some of the hearings about the landfill, didn't I? Maybe at the high school? And you recall a whole lot of people were complaining about odor. Would that be correct? Do you recall that?
Yes, sir.
Yeah, well, the biggest reason for that odor, in my opinion, or a big part of it, would be the shipment by Georgetown Sewer Company of septic waste. They ship at least, I talked with Frank Chisley just a week or two ago. He told me they ship at least one truck every week. A compactor truck loaded with septic waste goes to the landfill from the Georgetown sewage treatment plant. So I'm providing crops, and at the same time, I'm abstaining. I'm not a contributor to this landfill problem by diverting my septic waste out of the waste stream, out of the public waste stream, and processing it privately. So it has worked so well for me that I have advocated it at every opportunity. And on about May the 1st.
I understand your testimony. Do you have anything else, any other information to provide to the hearing officer regarding any other violations alleged?
Any other violations alleged?
In the violation that was sent to you on the notice of violation on from the inspection April 7th regarding 9-2, subsection 2, 9-2, subsection 7, 302.5, 304.7. Do you have any other information for which the hearing officer should be aware?
Yeah, well, let me wrap up real quick on the violation. The first one you mentioned is failure to maintain lawfully required water and sewer. That's section 992. That's what I'm talking about, right?
Yes, that's correct.
Okay, on about April the 1st, I went, we had another backhoe laying another sewer line, a little further down the street on Rucker Avenue. Roto-Rooter Corporation was installing a new sewer line. I went down the street on my bicycle, and the whole neighborhood was shaking. Had these yellow strobe lights, which are hard to look at. All this heavy equipment, a backhoe, a trackhoe, and a front-end loader, if I'm not mistaken, shaking the neighborhood to build a new sewer line up the man's driveway. They dug a big ditch, it had gone on at that time for several days. And as I said earlier, I checked with Roto-Rooter last week. They were there from March 31st through April the 11th. So I said to the Roto-Rooter man, buddy, you're causing yourself a lot of trouble unnecessarily. You're causing your client a lot of expense. If you want to see dry management of septic waste, you can come up to my house right here. It's the last house on the right. Come up and have a look if you want. I was trying to help him and his neighbor and the neighborhood, relieving all of us from the noise. And so Carter told me, this is the complaint, you have a copy of it, the complaint is dated, April the 3rd, is that right?
Yes, sir.
Yeah, April the 3rd. So my suspicion is that Roto-Rooter man or his customer complained. And in both cases, neither the case with my neighbors, in neither of these complaints did the complaining party observe an offense. They would have never known, just like William Carter would have never known, that I processed septic waste had I not confided to them that I processed septic waste. So it is not an offensive practice, and I have here a petition that was signed by my neighbors in 2000 and I'd like to exhibit this if I may.
Okay.
This was signed by my neighbors in this is dated 8/18/08. There are about 26 neighbors here, I think. I'm not going to count them, it'll take too much time, but I think there's maybe not that many, maybe 20 of my neighbors who signed this saying, we are not damaged by Stephen Price's use of buried septic waste as fertilizer for his crops and do not object to said use.
I have no objection. We'll generally object to the relevance of this line of testimony.
I would agree that I'm not sure of the relevance. At this point, I do understand Mr. Price's defense, and I think I have a handle on that, but I would sustain the objection. But that can be entered into.
How can it be irrelevant if you cited me for failure to use lawfully required water and sewer? That's exactly what I'm talking about. I'm telling you that the people who filed the complaint would have never even known that I was doing it until I confided to them that I do it. There was no odor and no unsightliness, as William Carter just told you.
Well, but that you made that statement. I have no idea who the referral came from, but you made that statement. It was properly referred, as far as we are aware, and as far as has been presented to this hearing officer, properly referred to the city inspection. The code enforcement went out, and through their investigations, discovered that you did not have the lawful sewer and water, so at the time. So whether or not you had confided this or not, that was their right or not. I don't know who made the referral, but it was their right or not to make that complaint to code enforcement. But I do understand your line of testimony and your defense regarding that. But I would think that we have gone over this road a couple times now through your statements, and I would sustain his objection to the relevance and ask you to move on. But we will
I don't mind moving on, but I don't see how you can sustain an objection to relevance. I mean, that's exactly what we're talking about. Mm-hmm. And in any case, the exhibit I already handed you indicates
Exhibit
that,
C,
that I have
yes.
complied with your notice I have remedied the violation by buying sewer service
Yes.
and water service. They're hooked up and functioning.
That is Exhibit
so
A,
that-
and
and again, I'll go back to the citation here. The citation says, if you remedy the violation with the time period specified, the penalty shall be waived. And so that's, I mean, I went straight, once I got this, I went straight to this is dated April 13th, and the paperwork, this is from the water company, dated, well, I didn't go straight, but dated April 13th. I engaged the water and sewer services on April the 27th.
Mr. Price, the hearing officer will recognize everything and review the evidence when I make my written findings of fact and conclusion of law, and you can be assured that what you have presented and the receipts that show that it is hooked back up will certainly not be ignored.
All right, thank you. So let's move on, as you say.
Exactly.
To section 9(2), parenthesis 7, right? We want to go there now?
Yes.
William Carter told me, and I told, when he showed me that, I mean, when I read this, I told him that the reason all the materials are there was because not all the materials, but most of the materials there were because I intended to build storage sheds behind my house, as well as a studio far away from the street where I can work with less noise, and a greenhouse. I told him that's why all those materials are there. Those building projects are underway, as you can see from the photographs. And the metal, the windows, I remember one complaint about the windows. If I want to have windows in these structures, then I need window frames, and the photographs of the windows were part of what was, I think, what someone complained about this morning. If I've salvaged those windows, and they will provide windows for the structures that I'm building. Let me look through there. Equipment, furnishings, appliances, scrap. There's some sheet metal there, which I will use it probably in roofing the structures, or possibly installing a sheet metal under a wood stove to protect the wood floor from combustion. It's common practice to put sheet metal under a wood burning stove. So that's why the sheet metal is there. Let's see. I don't think that any of the materials there are in any way dangerous to public health, safety, or welfare. Some people would say it creates an unsightly condition. Maybe that would be remedied if the materials are used in building these structures. So that alleged unsightliness would no longer exist. Is it too late now for me to ask William Carter a question? I mean, could I ask him a question or not?
I'm not sure where we're at, but on the direct versus cross-exam, but if you would like to recall him briefly, you may do so.
Thank you. Please.
Mr. Carter, please recall that you are under oath still.
Yes, ma'am.
Thank you. You may proceed, Mr. Price.
William Carter, you said that you had, Attorney Hartley asked you if you'd observed rodents on my property, and you said yes?
Yes, sir.
What rodents?
Mice.
Mice. Well, I'm looking at Save-A-Lot right over here. Save-A-Lot is just down I can see it through the window there. I buy mouse traps. If I need them, I can buy a mouse trap at Save-A-Lot store. And I heard a mouse today, a mouse this morning, as a matter of fact. I do have mice occasionally. And I do occasionally trap a mouse. But I don't think that's illegal, is it?
To have mice and trap mice? No, sir. I don't believe it is.
Well, I mean, if I have mice on my property, would I not be the first person to suffer the consequences?
Probably so.
All right, and I would be the person then to go to Save-A-Lot and buy a trap and trap the mice.
I don't think that he can answer that question. Of course, let me know if I'm incorrect, but I don't know if that's something that he has personal knowledge of whether or not you would have done, or if that was necessarily really a question. Try to restrict it to questions for which he may have personal knowledge.
Well, the answer to the question, the rodent you observed was a mouse, right?
Yes, sir.
Thank you.
Mr. Carter, when did you observe the mice, if you recall?
I don't recall.
Okay.
Was this at 167 Rucker Avenue? My current address?
Your current residence?
Yeah.
I've seen mice there, yes, sir.
But you were on the property, right?
Adjacent to, yes, sir.
I'm sorry?
Adjacent to, yes, sir.
I couldn't hear you.
Next door,
Next door,
adjacent to. not-
adjacent to.
Yes, sir.
And so you saw the mice from your observation off the property, you saw mice on my property.
Yes, sir.
Well, usually mice don't scurry around unless they're disturbed. Why would the mice have been observable if you didn't disturb them?
I have no idea, sir.
Can you explain to this group what they were doing, what the mouse was? How many mice did you see?
Just one.
And where was he? What was his location?
Somewhere near one of those wood piles, where it's all stacked up in a teepee against the tree.
And what was the mouse doing? I mean,
Scurrying along the ground.
and you could see that from the adjacent property, which is a good. How far away from the mouse were you?
About 10 or 15 feet.
Yeah.
Just about the same distance you and I are apart now.
Right. Well, I admit that there are mice occasionally on my property.
There's mice all over.
But I don't think.
Do you have any other questions for Mr. Carter?
No, thank you.
Mr. Carter, you may step down. And Mr. Price,
I'm going now to excuse me, go ahead.
I was gonna say, do you have anything to add regarding 304.7? Or if not, we will move on to closing statements.
Well, what about, let's see. Yeah, look, regarding rodent harborage further.
Yes.
Attorney Hartley just provided this group with Judge Isaac's order.
Yes.
It's exhibit,
Something around M, I think.
and that order specifically says that all ordinances of the town of Georgetown apply to my property. And among those ordinances is ordinance 06-027, which repealed the mowing ordinance that prior to 2006 required all vegetation be kept under 10 inches. But as of 2006, ordinance number 06-027 of the town of Georgetown allows what's called natural landscaping. And it specifically says that trees, shrubs, forbs, you know the word forb?
I'm sorry?
Forb, are you acquainted with the word forb, F-O-R-B?
I do not believe so.
Are you Attorney Harland, William Carter, Code Officer Carter, have you ever heard the word forb, F-O-R-B?
I've heard it before, yes, sir.
What's it mean?
I don't know what it means. You've used it several times.
I will say, Mr. Price, I don't think that you are being charged under that ordinance which you are citing currently.
No, but what I'm saying is that under the ordinance, I'm allowed to not mow.
I don't think you're being charged under that ordinance.
Well, but if you don't mow, then there are gonna be mice. And so if the way this complaint is that rodent harborage shall be kept free from rodent harborage. That, for most people, that means mowing. Most people don't rely on the ordinance 06-027.
Object to the relevance of this line of testimony.
I would sustain that. If you could please move on, Mr. Price. You're not being charged under that ordinance, so if we
Right,
could,
but the fact that I rely on that ordinance means that there will be mice.
you're
And
not-
so mice are the con.
Mr. Price, I've made my ruling regarding Mr. Hartley's objection, and it was sustained. Regarding relevance, I would ask you to move on.
Three oh 4.7, roofs and drainage, we already discussed. I came back, I went straight, after I got the citation, after I got the notice of violation, I went up on the roof, I removed the tree limb, I replaced a couple of loose shingles, I removed one shingle that was hanging over in the access space. I came down here, I told William Carter, that's what I've done. I said I didn't do any more because I was afraid I would make the roof leak. The more I do scurry around up there, the more chances that the roof would leak. And that's when he said, while he was under oath, that he responded, if it's not broke, don't fix it.
And it's your testimony, Mr. Price, that the roof does not leak?
It did not leak then, it's not leaking now.
Okay.
And I didn't want to create the possibility that it would leak by getting up there and dislodging any shingles. So that's, the only, and as for the drainage, flashing shall be sound, tight, and not have defects that emit rain. If the building were leaking anywhere, I would be right up there doing something about it. It's not leaking.
Okay.
And in roof drainage shall be adequate to prevent dampness or deterioration. There's no dampness or deterioration of walls. Roof drains, gutters, and downspouts shall be maintained in a good repair and free from obstructions. I rely on roof water for my crops, and I have been relying on it for drinking. So it's in my interest to keep the one roof drain that feeds the rain barrel unobstructed, which it is unobstructed. It just rained yesterday, the rain barrel is full. The fact that the rain barrel is full indicates that the drainage is not obstructed. And roof water shall not be discharged in a manner that creates a public nuisance. Did you see any public nuisance associated with rainwater discharge in my place?
Object.
He has already been recalled once.
You want to take this?
We've already recalled him once, but I have your testimony regarding the roof. He has been up on direct for Mr. Hartley, and he has been recalled for you. So I think that we need to move on from there. But I do have your testimony, and I understand your testimony as well as his testimony from prior, because I think he has testified regarding the roof.
Well, I'm just going to say then, if you don't want me to ask Carter, I mean, I would ask him if he saw any evidence of roof water discharge, it creates a nuisance. Could he just answer that from his chair?
I think that he has already answered those questions, as well as he's already been recalled and then released. So if we could move on to closing statements.
I actually have a very brief redirect, if that's okay.
Okay. Is there anything else, Mr. Price?
Yeah. I will read to you KRS 224. I won't take the time, I can recite it to you. KRS 224 43.010, I think it is. I'm not absolutely sure of the, I know it's chapter 224, but the Kentucky Legislature calls for reduction of landfill deposits. And by salvaging these materials, this complaint denigrates me for hoarding materials from construction sites. And I'm gonna tell you, if I didn't bring those materials home, they would have gone to the landfill. They were in dumpsters. I got permission to take them from the dumpster most of it at a construction, at a remodeling project up here by the old Kroger. And this complaint is true. I do haul it in a wagon and store it outside for the purpose of building these sheds. But my effort to salvage these materials and my success in salvaging these materials means that there is less chance that you, anybody in this room, will run into a trash truck hauling that lumber to the landfill. So I'm doing everybody a favor by keeping all these materials that are subject to this complaint, by keeping them out of the landfill, and maybe even more important, keeping them from being hauled to the landfill where they create a road hazard, such as the trash shipment that ran into a school bus here about 3 months ago. Fortunately, no one was injured, but last April,
I object to the relevance of this testimony.
it's not irrelevant. A trash truck last year killed a woman on the road. And by keeping this lumber out of the waste stream, I protect the public.
Please allow me to make a ruling, but I would sustain the objection of relevance. I do understand your testimony and regarding the legislature intent regarding keeping things from landfills, but I think we've gone astray of relevance. But so I would sustain that objection and ask that you move on. I think that do you have any other witnesses?
Did you say I'd gone astray of relevance?
That's correct. Regarding the citation, that is correct. Do you have any other evidence to present?
I'm looking. Yeah, hang on a minute. I will say that I guess I ought to point out that to do all this construction work, because I grew up on Rucker Avenue. My uncle owned a house on Rucker Avenue. I spent a lot of time on Rucker Avenue from my earliest childhood. And then I was away for a number of years and returned to Rucker Avenue, bought property there in 1990. I've been living on Rucker Avenue since 1990. So a lot of my life I've spent on Rucker Avenue. And I have watched, I recall from my childhood how peaceful Rucker Avenue was. No noise, relatively little noise. And that was a real blessing. That would make Rucker Avenue a pleasant place to live. And since 1990, when I resettled when I bought property on Rucker Avenue, my effort has been to preserve peace and quiet on Rucker Avenue in compliance with KRS Chapter 224 30-100, which I read to you earlier about noise. Mm-hmm. One way that I do that is to not use any kind of machinery. And so in building these structures, I rely on joinery. This is a book about joinery. Joining a building is.
I object to the relevance of your testimony, Mr. Price.
Well, I do. Then I don't object at all. And do you think if we're talking about if I'm going to build this building, what I'm saying is it's going to take me longer to do it because I'm not using noise-making equipment. And so I thought I would share that with you, I'm guided by this man right here, whom you may have seen on TV. You ever seen him on TV? Do you think that's what he does is worthwhile?
Mr. Price, He has made an objection, and I would sustain his objection regarding relevance. If you don't have any other evidence to present regarding the specific citation as to the,
Well, we're talking
Mitigation.
about the citation because we're just talking about disposition of the materials that are subject to the complaint,
I understand.
the lumber.
You have testified to that, and I understand your testimony. As to how they're being billed, I don't believe that that is relevant.
Well, what about chapter 22430-100? Is that relevant or not? Is noise a real problem or not?
That is not relevant to these proceedings, no. You are not charged under a noise ordinance. How the.
No, but the fact that I'm complying with the noise ordinance
Please be
makes me
respectful.
subject to the charge.
Sir, please be respectful to the court and to the hearing officer. I have made my ruling regarding relevance. I think that Mr. Hartley had asked for a redirect, which is within his realm. You can redirect after his redirect. So, Mr. Hartley, if you could proceed.
I would like to call Mr. Price back to the stand momentarily. I will keep this brief.
I'm sorry?
I will keep this brief. Mr.
Please
Price,
recall that you are under oath, Mr. Price.
Mr. Price, recall earlier that you stated that some of the plastic jugs that we referred to on your property were relocated. Could you tell me to where those were relocated,
Yeah, they're closer to the greenhouse site.
but still outside? Still on the exterior of the property?
Right, but they are, I've already located the site for the greenhouse. And some of the jugs are already there.
Thank you. Have you applied for a building permit for the construction of your, what you call it, a shed?
No, because under the Kentucky Residential Code, if your building does not exceed 120 feet, 120 square feet, you don't have to have a building permit.
And have you verified that with the folks at the building inspection office?
No, I don't have to. I got the you can read for yourself. The Kentucky Residential Code allows a building of 120 square feet. I explained that to William Carter. He didn't object.
Thank you. I'll turn your attention again to the ordinance, subsection 9-2, subsection 2, where it states, failure to maintain lawfully required water, sewer, or a source of heat to a dwelling shall be conclusive evidence that a dwelling is unfit for human habitation. You mentioned earlier that you process your sewage. Is it possible?
It's not sewage, it's septic waste.
Septic waste. You mentioned that you process your septic waste. Is it possible to both process your septic waste and maintain lawfully required water and sewer connection? You speak of the two as though they're mutually exclusive, or that they're not mutually exclusive.
Well, we're talking two different, we're talking water and sewer. You want to separate them one?
Sewer. The word is sewer. Is it possible for you to both have a lawful sewer connection and process your septic waste?
Yeah, but according to you, it'd be illegal.
Did anything in this notice of violation suggest that your processing of septic waste was unlawful?
Oh, wait a minute, maybe I'm wrong. No, I'm wrong. It says, what the law says is that I have to, what your notice of violation says, that I had failed to keep a legally required water and sewer. So, no, I suppose that there's no law, apparently there's no law against processing of septic waste. In this case, the law you applied is that I have to maintain sewer connection, which is now, with which I've complied.
You mentioned that the materials that are on your property, the lumber and other materials, that you salvage some of these materials. Can you tell me how you obtained those materials?
Which ones? I'll tell you how I obtained all of them. Which one you want to know?
Tell me how you obtained some of the lumber.
If you're acquainted with Georgetown Dudi, do you know who Georgetown Dudi is? Georgetown Dudi is a man from India who makes his living by ruining people's vision by putting eyeglasses on them. And he's got a big office building up here across Mount Vernon Drive from the old Kroger building. And Dudi sold the building to someone who's going to put a medical office in there. And they wanted all the existing walls out. And they took all the 2x4 walls out and threw them in a dumpster. And I went by there one day and asked the foreman if I could have the lumber. He told me I could have it. And I brought several loads home, and I still have some more up there to bring home.
Approximately how long have you been salvaging materials at your property?
I've been salvaging materials ever since, as a young man, I realized the problem we have with landfill. And to answer your question, at the property where I live now, I've moved there in 2004, so the answer is 2004.
Okay. So have any of the materials that are on your property now been there longer than, say, 3 months?
Yes,
How about longer than 6 months?
yes,
How about longer than a year?
yes.
Okay. How about longer than 2 years?
Well, I'll tell you, Hartley, the town
I'll withdraw that question.
The town removed everything in 2014. So whatever is there I have acquired since 2014.
So, a moment. Subsection 7 states that the open storage of equipment, furnishings, appliance, scrap, or salvage materials is a nuisance unless said items are stored in a storage, fully enclosed structure, or those materials are not being actively used for construction. So is it your contention that those items that have been there for longer than 3 months, longer than 6 months, longer than a year, are all actively being used for construction?
Yes, sir. They are now.
They are now.
Yes, sir.
Were they 3 months ago?
No, because I knew that I wanted to build these structures, but first I had to assemble the materials, and so I didn't begin to, as long as I could access and retrieve materials, and while, as I mentioned, at the same time keeping them away out of the landfill, then I brought, wherever I would find the materials, I bring them home, and knowing that one day I would use them to build these structures that I want. And when Carter told me, you can't have the material on the property unless you're using them for building, I said, okay, I'm going to go to building, and which is what I've done, and which these photographs indicate.
How long have you lived at 167 Rucker Avenue?
Since 2004.
Since 2004. When you first moved into 167 Rucker Avenue, was there a gutter on the front of the home?
No.
Were you aware that there was a gutter on the front of the home before you moved into the house? You mentioned
Well,
before...
let me answer your question again. Let me say, I don't recall whether you're talking about across the front porch that we're looking at right there in the photograph.
Yes, sir.
Frankly, I don't recall. I'll have to admit I don't recall. But if there was a gutter there, I I had no need for it because I wanted the roof water. And I don't think there was one there. I think had there been a gutter there, I would have relied on a downspout to feed a rain barrel. And but that's some trouble to install, and it was easy for me to simply drain the roof directly into what do you call it, a long wash tub sitting just beneath the roof line, or a series of 5-gallon buckets that I install beneath the roof line when it rains. And that supplies all of my water.
So you stated that you've lived at various times in your life, all your life, on Rucker Avenue. Is that correct?
No, not all my life. No, but
Various times.
at various times, from about age 6 until maybe age 16 or so. My uncle had a house on Rucker Avenue. I was there a lot.
So is it your testimony that at none of those times was there ever a gutter on the front of that building?
I don't know. I didn't have that house until I acquired that house in 2003. So I don't know what happened during any other times than that.
I have no further questions.
Thank you. I think we can move on now to closing statements, and each side will have 5 minutes. So, Mr. Price, if you would like to step down. Mr. Hartley, we can start with you.
Thank you. The city has demonstrated by substantial evidence that the property at 167 Rucker Avenue is in violation of Code of Ordinances, Section 9-2, Subsection 7, and Property Maintenance Codes, Sections 302.5 and 304.7. The city consents to the dismissal of the charge of violation of Code Section 9-2, Subsection 2 for water and sewer connection, provided that it reserves the right to bring same charge for any future violations. The city hereby respectfully requests an order compelling Mr. Price to remedy these violations not later than 30 days following the date of the hearing, provided that if there is substantial progress, that date be extended to no longer than 60 days. And further requests 60 days following the date of the hearing officer's final order, and further request, in the event that all or some of the violations remain at that time, that the city be authorized to abate the violations according to the terms of Ordinance 16-009. The city further requests that a penalty of $100 be imposed upon Mr. Price, said penalty to be increased to $1,000 if violations remain after the date set for remediation. The city further requests the cost of this hearing and of any other necessary abatement be assessed against Mr. Price. That's all I have.
Mr. Price, do you have a closing?
Yeah. Now, I'm going to repeat to the group assembled that my use of salvaged materials benefits me, obviously. The tin, you can see the used tin on the roof of my house. That tin would have been in the landfill had I not salvaged it. It's keeping me dry today. The plastic jugs, I worked for a year and a half at Little Caesars Pizza. Those plastic jugs caused Little Caesars to ship Herbie Kirby's hauled by the town of Georgetown. 5 of those jugs would fill up a Herbie. And you know what I'm talking about, what they call a Herbie Curvy, a trash cart, the official trash cart of the town of Georgetown. 5 of those jugs would fill up the Herbie, fill up the trash cart. So I asked my boss, I said, can I take those home? And he said, yeah, because that would save us having to ship them. So those jugs would now be in the landfill had I not brought them home. And as I told this group, I intend to use those jugs to build a translucent greenhouse that would emit light, and I may fill them with water and use them for a thermal wall, which would keep the greenhouse warm at night. And so, for me, I mean, what most people would see as refuse, the jugs offer an opportunity to raise crops in a greenhouse environment. And that's why the jugs are there. And for Attorney Hartley to simply write them off as trash or refuse is erroneous and damaging to the public interest, because if I have to get rid of them, they will go to the landfill. And if they go to the landfill, they have to be hauled to the landfill, and that creates a road hazard, such as the road hazard which killed a woman in April of 2016 and collided with a school bus about 3 months ago. So by isolating these materials, bringing them home on foot or on a bicycle or on a wagon, or what the man called a wagon, a cart, that doesn't require motorization, I bring them home, I keep them out of the landfill. I'm doing you, everybody in this room, I'm doing everybody in this town a favor by keeping them off the road to the landfill and by keeping them out of the landfill. The same can be said of the lumber. The same can be said of any sheet metal. And do you recall, I mean, well, he's not on the stand, but I'm trying to recall any other. The same can be said of the septic waste. The septic waste, as I said earlier, the septic waste will be shipped to the landfill if it gets flushed into the public sewer treatment plant run by the town of Georgetown. And by diverting it away from that waste stream and keeping it stable, stationary, or not, in other words, keeping it at home and at the source point of where it's generated. That's the way trash should be managed, at the source point, so that it does not have to be shipped anywhere. And I had a big long letter that I wrote to, I think it's in the file, about that. It was published in the News Graphic. What I'm trying to do is source point management of what other people throw away. And I'm doing everybody a favor. I'm leading, hopefully in the right direction. Hopefully I'm leading. I don't know, maybe not. I mean, if people don't want to be led, some of them will react and just tell me, well, I have to get rid of it all, which I guess if to keep my property, I'll have to do. But I hope that this body understands the importance of seeing waste materials as useful and thus rebranding them as valuable materials as opposed to trash.
Thank you, Mr. Price. Your 5 minutes have elapsed, but thank you for your closing statement. Regarding the city's motion to dismiss 9/2, subsection 2, I will sustain that. So the first violation was dismissed on motion of the city, which would be that you remedied the city and water.
All right, thank you.
Regarding violations 9/2, 302, 304, I would make my rulings in a written findings of fact, conclusion of law that will be sent to the city and to Mr. Price. Would the best address to send that findings of fact, conclusion of law be 167 Rucker Street, Mr. Price?
Rucker Avenue.
Okay, Rucker Avenue, I'm sorry. I will do so, and I will try to do so in all haste for all involved. If we could get,
May I comment?
okay, briefly, yes.
Haste makes waste.
Okay. Well, I will try to do so with my schedule in a way that is reasonable to all parties. But I understand that I am not going to, I have not presupposed an ending to your case. I'm going to review all the evidence, and I will make a written findings of fact, conclusion of law. Okay.
Thank you.
If we could get copies made, one for my file, and then I'm sure Mr. Hartley. One. Thank you so much. Other than that, I think we are convened for today.
Thank you.
Thank you.
We are what for today?
Convened.
Then we better
we're-
sit back down.
Oh, I'm sorry, you're correct. We're concluded.